Hey, good afternoon, everyone. My name is John Hurley. I'm your judge this afternoon. We're in first appearance court. Today is the day the court determines whether or not there's probable cause for your arrest. We're not here for a trial, not here to prove that you're guilty or not guilty. It's not for today. Please do not tell us about your case. Do not explain yourself, defend yourself, make excuses. Those things are not for today. Those are better saved for your attorney in a private meeting. You have the right to remain silent, but if you give up that right, whatever you say, Canon will be used against you. Everything today is being recorded. Also, if you have a private attorney, when you're called up, let me know who that is. Contact your attorney and let them know that you're in court. Now, who do we have in front of the court right now? What's your name, sir?
Jason Lawson.
That's your client, Lawson, right?
Yes, sir.
Just have a seat, because I think we're waiting for a special prosecutor on the case. We have a prosecutor from the state attorney's office, and I think she's going to be here shortly. Say, do you have anything you want to call now?
Yes, Judge.
Who's that?
It is from this morning. It's reset from this morning.
Mr. Miller.
Yes.
I think you.
Go see Wayne Miller, please.
Yes, sir.
Okay, Mr. Miller, you have the right to remain silent today. If you give up that right, whatever you say, Ken, will be used against you. We don't expect you to make any comments, to explain what did or did not occur, or to make any excuses, or anything like that. It's not needed for today. You don't need to talk. You probably shouldn't say anything. Wait to speak with your attorney in a private meeting, all right? Now understand, if you decide to say something today, everything's being recorded, and the prosecutor can get a copy of the recording and play it for a judge or a jury in the future, and it probably would not be good for you. Do you understand that?
Yes, sir.
Okay. Now, Mr. Wayne Miller, you have 3 charges. You have count 1's a battery, 2 is a sexual assault, and then count 3 is a tampering, and a life or capital felony proceeding. Now, state, what's your position on this?
Your Honor, the state is seeking to hold the defendant without bond on counts 2 and 3. I'm sorry. Yes, counts 2 and 3.
Line franchise or city keys their phone number.
So, you're 2 and 3 are, 2 is a first degree PBL, and it's 3 a capital felony or PBL?
PBL.
So they're both PBLs?
Yes.
Not capital, sorry about that. Okay, so, now, do you have somebody who wants to testify?
Yes. Detective Martinez?
Okay, anyone else?
No. Just,
Ma'am, raise your right hand. Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth?
Yes, sir.
Okay, tell us your name, ma'am.
Yvette Martinez?
Okay, and you are a detective in the city of Fort Lauderdale?
Yes, sir.
Okay, and on January 12th, 2015, did you have an opportunity to investigate Mr. Wayne Ferris Miller regarding a alleged sexual battery which occurred in the city of Fort Lauderdale?
Yes, sir.
Okay, go ahead, state.
okay. Detective, I know and I've read your probable cause affidavit, and it goes into detail what occurred. I just want to, just a few things I want to go over with you. You mentioned in your PC that the defendant, well, first off, did you take a sworn statement from the alleged victim?
Yes, I did.
Okay, and it states that the defendant deprived the victim of her cell phone in order to not allow her to call for help. Could you please tell the court, based on the information you received from the victim, what did he do to deprive the victim of her cell phone?
He took the phone from her and he hid it somewhere where she wasn't able to find it.
And at some point while this was going on, the victim tried to escape from the defendant, escape the residence?
Yes, he did.
And what occurred when she tried to do that?
He cornered her at the just at the in front of the door to leave the apartment, and he choked her. At which time she pleaded for him to release her because she couldn't breathe.
Okay, and now you took a statement from the victim, so you had an opportunity to physically observe her when you took the statement?
Yes.
And approximately, how many hours after this allegedly occurred did you take the statement from her?
She stated it occurred somewhere around 2 o'clock in the morning, and I took her statement at about 9 o'clock in the morning.
Okay. And you observed injuries she suffered.
Yes.
And you also took a post-Miranda statement from the defendant, correct?
Yes.
And his explanation for these injuries she suffered to her face was that she caused them to herself, correct?
Correct.
Okay. Let's see.
That would be today's. Then yesterday's are in there. Yes.
Detective, I'm showing you these set of pictures. And are you familiar with the images in those pictures?
You haven't given me back all the pictures.
No, in the pictures I've given you. Are you familiar?
These are the defendant's pictures.
From when? When were they taken?
This was taken right after I interviewed him.
And are they a fair and accurate representation of the injuries you witnessed on her body or her head at the time you interviewed her?
These are the defendant's pictures.
Oh, I'm sorry.
There's 3 sets. This is the defendant. Okay. Do you have another set of pictures in the envelope?
Detective and all the attorneys we obviously know, I just want to remind people not to, we're not going to say the name of the victim, just use initials, right?
Those
Yes.
are all.
Yes. Okay. These are.
And you have copies, originals of these copies?
Those are copies.
Okay.
And you also, pictures were also taken of the defendant, correct? Okay. Let me show you. Would you please tell the judge what the images and the photographs I've just shown you are?
One of his right, he's showing me injuries on his right elbow that he says was a bite. And the other one is pictures of both of his hands, where on his left hand, he indicated he was bit by the victim.
Okay. And is that are those fair and accurate representation of the observations you made when of the defendant at the time?
Yes.
Your Honor, it's not
Okay. Any objection from the defense? You want to put these in evidence at this time?
Yes.
Any objection by the defense? I have a picture of a woman, and I have a picture of what looks to be the defendant. Any objection at this time?
I reviewed them, Judge. I have no objection at
Okay,
this time.
so let's be clear. This is only for the purpose of first appearance. So later on, there could be an objection at trial. But for first appearance, if the defense ever took a writ, we have to have these in evidence. So now, what I will do is I'm going to bring these into evidence, but I'm going to ask the clerk if they can do it somehow to seal the pictures of the victim, because it would reveal they're only to be looked at by the trial judge and sealed till further order of the court. Now, so I'm looking at what appears to be an African-American female. Okay, the court has reviewed those photos, and the court is going to look at the photos of the defendant. Okay. Okay,
Okay.
State, you may continue.
Thank you, Judge. Detective Martinez, based on the observations, based on the observations that you made of the victim's physical injuries and the information you were given by the defendant, did you see any evidence to indicate that the victim caused her to suffer those injuries?
No.
Was there any evidence, and also was based on your experience in your investigation, was there any evidence that the victim bit the defendant to the point with such severity that it would require him to, in his own words, choke the victim?
That's that's asking for.
Well, Your Honor, officers are investigated to make a determination. They're asked to make a determination if someone's acting in self-defense.
Judge, I'm
Based
going to
on-
just
I'm-
make
I'm-
it.
Your Honor, officers are asked to make determinations based on the evidence, the observations they make, the information they're given to determine if someone's acting appropriately in self-defense or not, Your Honor. He's making a claim he acted in self-defense. I'm just asking, based on her investigation and the physical observations she made, the information she was given, the statements that were made, if she had any evidence to indicate to her.
Judge,
Go ahead and
I'm objecting to opinion and speculation.
granted, it calls for speculation. You may, go on to the next question.
Okay. And was a rape kit conducted with the alleged victim?
Yes.
Okay, and when was that conducted?
Right after I took her statement, she was transported.
Okay, and do you have the results? to that?
Not as of yet.
Okay, and is it normal that you would not have the results the day after?
Yes, because they have to review the information before they release it.
Okay. Your Honor, I have no further questions.
Okay, I just have a few. The alleged victim went to the sexual, I'm not sure the name of the treatment center, Nancy Cotterman?
Yes.
Okay, did they, without revealing her medical privacy issues, but was there a determination that this had been sexual contact that was uninvited, or was there any injury consistent with sexual assault or sexual battery that you know about?
I have not spoken to them to get those results. Like I said, as of today, that report was not ready yet.
And the testimony is that the violence that is evidenced clearly, the resulting violence on the female, that violence occurred prior to sex. Is that what was told to you?
Yes.
Okay. And
Well, matter of fact, according to what the alleged victim told you, did she, during the actual sexual act, did she physically resist at that point?
Initially, she told him no, but he became angrier, and in order to keep him calm, she went ahead and just asked him to put on a condom.
But other than what she said, did she do anything to physically resist?
No.
And did she give an explanation why she didn't do anything to physically resist?
Because she had already been beat up. She said she was afraid that he would do more.
Okay. And I just want to clarify something, because it mentions in the report that the defendant fell asleep after this act. And did you get an explanation for why the victim did not flee from the home?
She said that she had already attempted to flee once, and that's when he cornered her and he choked her, and she believed at that time that he would kill her. So when he fell asleep, she still did not feel safe enough to be able to get up and leave, And she said she couldn't find her phone, and when she did find it, it wasn't working initially, and then when it did work, that's when she was able to call for 911.
I have nothing further.
Yeah, let me just ask you a few questions, ma'am. Do you know ultimately where the cell phone was found?
I don't know.
Now, do you know if it was within the apartment?
She lives in a really small apartment, so it was somewhere within. I'm not sure what part of the apartment.
Were you able to determine whether these two ever had any kind of sexual relationship in the past?
Yes.
And did they?
Yes.
They did. Okay, and how long before this had sex occurred between the two of them?
According to both of them, it's been a total. This incident would have been the third time. According to him, consensual. The last time was 2 weeks ago, and the time before that was about 8 months ago, according to the victim.
Judge, may I ask just one question?
Well, here, why don't you tell me?
In Your Honor, this, and I really should have objected yesterday.
Okay.
I'm going to object. Your Honor, a question he asked you that you ask is still a question from the defense.
Well, I'm gonna ask him what his
I'm just objecting for-
interest is, and then I'm gonna go ahead and I'll decide whether to formulate a question.
Okay. I heard something about the report was made around 9 o'clock in the morning, and the incident is alleged to have occurred the night earlier in the morning, like 2 o'clock in the morning, some 7 hours earlier. Did the detective have an opportunity to see the alleged victim in this case at the time of the report?
Well,
And if so, how fresh were the injuries?
the premise of your question, I got a head shake in the negative on. I think the time is an issue here. Go ahead, detective.
I met with her a little bit before 9. I received a phone call from the arresting officer, Officer Campbell, at 8:10 in the morning, telling me that he was at the scene with Mr. Miller in custody. I don't know what time exactly he got there, but it was sometime before 8 o'clock in the morning.
Okay. All right. So, is there any argument that the defense would like to make at this time?
Judge, I would just argue there's no probable cause for a sexual battery. It seems that there's no nexus between the alleged battery and then the alleged intercourse. According to the probable cause affidavit, she said no. He insisted. She relented. She says it was because she felt in fear, but there's no threat of, at least not in the probable cause affidavit or from this testimony of the detective, there's no threat of, if you don't, I will do this. There's no actual threat. There may have been, there's alleged to have been violence and there's alleged to have been intercourse, but there's no connection between those two. And if that's the...
Go ahead.
I was just saying, it says he insisted, she relented, asked him to wear a condom, and he didn't.
It says right here, he began to choke the victim and pleaded with him to let her go. She was unable to breathe.
Right.
The victim ended up on the floor with the defendant on top of her. The victim told the defendant several times she did not want to have sex. However, the defendant insisted. The victim, fearing for her life, after being severely beaten up by the defendant, gave in and requested he wear a condom. The defendant proceeded into sexual activity without a condom.
Judge.
The court reads that and interprets that to be one continual act. That there wasn't, the way it's written, seems to be one continual act. Doesn't seem like there was a break and a rest period there. Is that
Judge.
fair to say?
Yes.
Okay.
Judge, I think the other issue is, could they have had consensual sex, had an argument afterwards, and then the battery occurred? I mean, that's something that's it's questionable, and that's something reasonable minds could differ. I mean, did they have consensual sex? They had an argument about something, and then violence ensued. You know, there's no way to say that the violence occurred in the act of the alleged act.
According to the defendant, when I spoke with him yesterday, he did tell me that the violence occurred prior to, he admitted to choking her, and then he said that after that is when they had sex.
Okay. All right. This court today will find proof evident presumption grade as to count 2 and count 3, sexual assault / sexual battery with the alleged victim. The court bases it not only on the affidavit attached here too, the testimony from Detective Martinez of the Fort Lauderdale Police Department. The court also reviewed the photographs which have been put into evidence as states 1 and 2 for the purposes of first appearance. And the court does note the level of violence. The court does note it does appear the victim allegedly suffered a severe beating as by looking at her face, both eyes. One was closed and one was about closed from bruising and marks on her face. And it does seem that there was a high degree of violence. So there does seem to be a consistency here with the testimony of the alleged victim and the defendant and the physical evidence. So the court will order the defendant be held without bond on count 2 and 3. Now state as far as count 1 goes, does this defendant have a criminal record?
2010 possession of cocaine, 2009 possession of cocaine, 2007 introduction of contraband into a detention facility, just under 24-month state prison, 07 possession of cocaine.
Okay.
He's got 05 possession of cocaine, 03 possession of cocaine, 01 grand theft auto, 2000 battery, assault, 2000 possession of cocaine, 93 delivery of cocaine, 3 years state prison.
Okay. Mr. Miller, anything about the defendant's ability to post bond on count 1?
We're going to stand mute, Judge.
It's going to set his bond at $10,000 on 1. He has a prior battery, and he has a lengthy record in noticing the level of violence. The court will order the defendant to have no contact with a African-American female with the initials of TJ, that is Tango Juliet. No contact directly or indirectly. And thank you very much, sir. You'll be held without bond on 2 and 3. Now, may I see, you ready to go?
Yes, sir.
May I see Jerry Vaughn, David Johnson, and Stephen George. Vaughn, Johnson, and George. Jerry Vaughn. Hi, sir. Mr. Vaughn, you're charged. You have 2 warrants for soliciting or panhandling. I'll appoint Mr. Shate to represent you. Mr. Shate, Mr. Vaughn wants to resolve them both today. The court will give him 60 days on 1, 60 days on 2 to run concurrent. It's pretty chronic at this point.
I understand, Judge.
Mr. Vaughn is in here every week or so. It's the same thing, and it's a never, it goes on and on. So,
I understand, Judge. I'd suggest that Mr. Vaughn not accept that, Judge, and I'll talk to him in court about the reason why.
okay. His
Just
bonds
like
are going to be $100 on count 1 and 2 in the court. The court takes notice that this defendant has no money to bond out with. And all
Yes,
right.
sir. Thank you, Judge. I'll see you in about a week, Jay.
There you go. How about David Johnson? Mr. Johnson, consuming alcohol in public. Turn on that mic over there for us.
Mr. Johnson, hit that button on the table.
Okay, Mr. Johnson, are you currently employed?
Yes, sir.
What type of work do you do?
I work at Harbor Freight and Tools. We just opened a store in Hollywood, Florida.
Do you have any money in the bank?
No, my girlfriend has all my money.
Do you have any financial means to hire your own attorney?
No,
Do you
sir.
want me to give you a free attorney today in the courtroom here? He can represent you today. It's not going to cost you anything.
Okay.
Okay? So
Okay.
I'm going to appoint Mr. Shate. Mr. Shate, if this defendant wants to plead no contest, the court will accept it. You'll get a withheld adjudication. I don't know, does he have a criminal record?
I've never had him.
Sure, I'll give you a choice. You can bond out for $25 or plead no contest. The case is over with today. What do you want to do?
I would like to plead no contest, sir.
You understand we're not going to have a trial. You're not going to have your day in court. It's wrapped up right now.
Yes, sir.
Okay, sir. I'll accept that. Mr. Shade, how do you feel about that?
That's fine, Judge.
I'll withhold adjudication. Good luck, sir. Thank you.
Thank you very much.
Yes, sir. How about Stephen George?
Yes.
Hi, Mr. George. You're here for multiple warrants of loitering.
George.
Sir, do we have a report finds probable cause? Are you currently employed, Mr. George?
You have a job.
Are you employed?
No, I don't have a job, but I go to a program for for the other court that they sent me.
Okay, do you have any money in the bank?
No, I don't have nothing. There's nothing. I don't have nothing.
Do you have any financial means to hire your own attorney?
No, nothing. There's nothing. No
Would you
bond.
like me to give you a free attorney who's in court with us today?
Sure.
Okay, so I'm going to appoint Mr. Shade. Now, is there a criminal record on this person?
I need a BCCN number, Judge.
It's 846830.
Yes. Arrest last September for prostitution. I'm not sure what happened with the case. Then 2004.
Set him up.
No, it was a state charge.
Okay.
Then December 2014, another prostitution.
14, a prostitution also.
No, no es.
It looks like one pled out and the other might still be pending. The 2014 pled out. The 2015.
Mr. George, what's your address right now?
My address is 2244 Arthur Street, Hollywood, Florida.
Okay.
The 2015 is still pending. He's in a program. I guess he's in drug court, Judge Zeller.
Yeah.
Steve.
He's gonna put something up and that person's gonna be there tonight. Did you say 2244? He's in drug court now? Screw him up. Yeah. He's in the booty from the drug court anyways. Looks like that.
Oh, that long name? Yeah.
I'm going to go ahead. I'm going to.
But where is?
Who's going to bot you out of jail today, Mr. George?
Nobody. I don't have nobody.
Who does he live with?
I live with my mom.
Right? Is your mom working?
My mom is working right now, yeah, but she don't have time right now. Like, she's always busy.
I'm going to lower your bond to $100. You have 2 prior prostitutions, and this one I'm going to lower your bond. You can bond down to $100. Thank you. You can call your mom.
Oh, excuse me, say it again?
Your bond is $100. All right?
100. Okay,
Thank you.
thanks.
Papers George made up.
Okay. I think.
That's it?
Judge John Stinson's in North Broward. Looks like he belongs to Mr. Shea.
Well, that's count 2.
What's that?
You want to split it.
No. It's
It's just that it was, it's just when they submitted. It's just a receipt. Where's Stinson? Stinson, where are you, sir? North Broward. I don't see him there.
here's how it happened.
Pencil? Judge, at the main, this is James Papers. It looks like it belongs to Mr. Shea as well.
Charged with resisting arrest and count 2's municipal ordinance, City of Hollywood. And, Mr. Stinson, are you currently employed?
My name is not Mr. Stinson, sir.
That's what I'm saying, don't worry about it, because
What is your name?
no matter what happens, you'll be fine, because I'm
Main jail.
happy about the way things
Sir,
Judge, this is Mr. Capers.
yeah, Mr. Capers, you don't need to say anything. We're working on another case right now, right?
Okay.
Okay, Mr. Stinson, can you hear us?
This is
Yes.
Mr. Stinson, you've been charged with resisting arrest and sleeping in the park or living in the park. Would you like to resolve your cases today?
Yes.
Now, do you have any money in the bank?
No.
Are you employed?
No.
Can you afford your own attorney?
No.
Would you like me to appoint a free attorney to help you today?
No.
Okay? Sir, if you plead no contest to these two charges, they're over with today. You don't have to come back to court. The case is wrapped up. Is that what you'd like to do?
Yes.
How do you plead to these 2 charges, sir? No
None guilty.
What is it?
None is guilty.
I don't understand. Sir, if you plead guilty or no contest today, the cases will be over with. If you plead not guilty, you can go to court in the future. So what would you like to do?
Well, I'm not guilty.
Okay. So what I'm going to do today is, do you have an address, a local address, sir?
Not in the state of Florida.
How long have you been here in the state of Florida?
A few months.
Do you have any family here?
No.
Okay. Do you have any financial ability to bond out of jail?
No.
Do you have a
Oh, I got
Do
it.
you have any address here where you're going to go when you get out of jail?
No.
Okay. Do you have a P.O. box here? A mail drop?
No.
Okay.
No.
Look, sir, here's the alternatives for you. Number one, I'll give you a bond of $100 on count 1, and you can bond out. But it appears that you can't afford a bond. So you'll be sitting in jail for a while, maybe a couple of weeks. Option 2 is plead no contest, and the case is over with today. You don't have to come back to court. We'll close out the case, and you'll leave jail today. Do you understand that?
Yeah. I
Okay.
understand.
What would you like to do? Plead no contest?
Yeah.
All right, you understand the case is over with. There's no trial. You're not going to have your day in court. Is that clear?
Yeah.
Now, do you think you're being forced or pressured to make this decision, or are you doing it because this is what you think you want to do?
Yeah.
Okay. All right. Now, how do you plead? No contest?
Yeah.
Yeah. Withhold adjudication. Thank you, sir. Okay. So I think that's it.
That's it? Okay, Judge. Take care.
Judge, what about Mr. Chambers over here at the bank?
Who's that?
Okay.
No.
What's your name, sir?
James Caver, sir.
I don't know why we have James Capers here. Is it? Somebody. Wait.
I can tell him, Judge.
Hang on.
Maybe I don't want to bother him.
Hey, Mr. Capers, if you have a seat, we'll be right back with you.
Sure.
Take a seat right here.
Frank Castro.
Caleb?
Come on, Caleb, Rock.
Mr. Castro, you're here on battery on a person 65 years of age.
Oh, these are wrong
We're
things.
already appointed a public defender, ordered a mental health screen. And then
Go ahead, you're right. Go ahead and have a seat.
we have, qualifies probable cause. Do we have any priors on this gentleman?
1 moment, Your Honor. Yes.
About ready to go?
Yeah.
Did you call him, Mr. Shea?
Yes, I did, and I texted him.
Okay, so
Officer,
okay.
one count of battery. It was domestic against a family member. Resisting with violence, resisting without violence.
Okay. Mr. Castro, are you currently employed?
He's in the bathroom.
No.
Do you have any money in the bank?
No.
How long have you lived here in South Florida?
20 years.
Okay. Well, this is clearly an issue that,
A little bit. I had time to wash my hands on.
okay, I'm gonna set his bond today at $2,500, all right, based on
Not this
his
guy.
prior battery, but the court also notes that there's a mental health issue here that is set forth in the probable cause affidavit, and it's being addressed by the public defender's office, all right? Thank you, sir. Okay, James Capers, come on up.
Just here.
Mr. Capers, you have two warrants, both for open container alcohol. I find probable cause. You currently employed?
Yes, sir.
What type of work?
General labor.
Do you have any money in the bank?
No, sir.
Can you afford to hire your own attorney?
No, sir.
Would you like me to appoint a free attorney for you who's in the court with us? He can help you out today.
Sure, yes.
Okay, so I'm going to give you Mr. Shake. Mr. Shake, Mr. Capers wants to plead no contest to these two charges. They're over with today. We're not going to have a trial. They're wrapped up right now. How do you feel about that?
That's fine, Judge.
You want to do that, sir? You want to plead no contest?
I plead no contest, sir, yes.
All right.
Yes, sir.
How do you plead, sir?
No contest.
Okay, I'm going to withhold adjudication on both. Now, I do think that's it, Mr. Shake.
Thank you, Judge.
Here you go.
Yeah.
Are we ready to go?
Yes.
Jason Lawson.
I think you're better off having a private attorney.
Okay, Mr. Lawson, you have the right to remain silent. If you give up that right today, whatever you say can and will be used against you. You have an attorney, Mr. Maloff, in the courtroom with us. You should allow him to speak on your behalf. You don't need to say anything unless you're asked a question. Do you understand that, sir?
Yes, sir.
Okay, good. Good afternoon, Mr. Maloff.
Hi, Judge. May it please the court. Robert Malov on behalf of Jason Lawson.
It's your citizen on behalf of the state.
Okay, and we have this defendant charged with false imprisonment of a, it says of a child, it says under 13, is that correct?
The child was 13, Your Honor.
So, does it matter for the charge? Is it under 13 as a first degree PBL?
No, it's a third-degree felony.
Okay. And then count two's abusing a child with that great bodily harm.
Child abuse is also a third-degree felony.
Okay. So, do you have any issue about probable cause?
No, Judge, I have some information that's not contained in the arrest affidavit that you should become aware of.
Okay, go ahead.
Judge, can I just renew what I had made a concern earlier in the morning that Mr. Malov also represents Mr. Lawson's co-defendant, Arturo Martinez?
Okay, is there
No conflict.
no conflict? Have they waived?
Well, they will, but at this point, I didn't expect Mr. Lawson to be here today. But you can ask him if he has any issue. It's theirs to waive or theirs to invoke. But there is no pointing the finger at each other, and they are not at cross purposes.
Well, the court's concern is that if we went forward, that there was not a proper waiver, you come back on the 3.85 and, in this case, come back maybe in the future.
Well, I don't know if I need to do anything other than stand by while you set the standard bond.
Okay, but you were going to offer some other information.
Yeah, I think that it's helpful for you to know, based on the information that I have received, either from the state or from other investigation, that apparently that this was.
Well, before you tell me.
Yeah.
Let me
What would be
talk-
the standard bond, Judge?
Okay, let me talk to the defendant. Mr. Lawson, we
Yes,
have
sir.
a situation where you have a co-defendant. Someone else was arrested for the same alleged criminal activity. You were aware of that, right?
Yes, sir.
Okay, now, the issue we have here, it's not anything you've done wrong or nobody's holding you accountable for this. However, I want to be clear about something. We have Mr. Maloff, who's representing your co-defendant, and he's here today. I guess you would only be his attorney for today, am I correct, sir?
No, I'm going to file a notice of appearance, and we can address the Neal issue before Judge Bailey, if it becomes necessary.
It's a bit unusual that one lawyer would represent two defendants on the same case, because and there's some ramifications to that. If you tell Mr. Malo something in secret, in confidence, which a lawyer has to hold in confidence, and he represents your co-defendant, and the co-defendant tells him something in confidence, then Mr. Maloff is put in a position where he may be representing two competing interests, or, you know...
Have to withdraw and not be able to represent either one of them.
So there's a lot of, there's a can of worms that could get opened on things like this, and it could end up being detrimental to you. But for the purpose of today's hearing, do you mind if Mr. Maloff represents you today?
Yes, sir.
Is that okay with you?
Yes, sir.
Okay, so that's okay with you, and then after today, this matter, I guess, will be brought up with his trial judge, right?
What matter?
Well, about Mr. Maloff representing both people. I mean, doesn't there have to be, is it a Neil here?
I think it's Neil.
Both defendants have
Right.
to waive the conflict.
Just for today.
Okay.
We're gonna go past today, and then afterwards, you can readdress it with the trial judge, all right?
Judge Bailey,
Okay, and I'm not saying that Mr. Maloff is doing anything wrong. I just wanna make sure we cross the Ts and dot the Is. That's all.
Fair enough.
Now, that being said, does this defendant have a criminal record?
No.
No criminal record. Is there anything you'd like to say?
Judge, these defendants were on a cruise ship. This 13-year-old victim was harassing a child on the cruise ship. Information that I have is that this defendant and the other defendant were inebriated and retaliated and committed the alleged conduct or allegedly committed the conduct that's set forth in the probable cause affidavit because they were allegedly defending this young child who this 13-year-old was stalking during the cruise. Right. And it's a sad situation, but I think because alcohol was involved and parents were upset about an 11-year-old being stalked by a 13-year-old, things got out of hand. And that's what you needed to know, that it wasn't just, let's find some 13-year-old to do these kinds of things too.
Well, when the court read this morning, the court got that issue. There was no doubt that you had an upset parent and an upset uncle, from what I can see, a parent and uncle, about what this young man was coming on to the girl. No doubt about that. Any parent reasonably would be upset about that. You'd probably take action. But, that being said,
a crime may have been committed, right, I understand.
Question. I mean, he could have gone to security, could have done a few other things instead of take it, where it went. Go ahead, ma'am, do you have something to say?
Your Honor, I think the probable cause affidavit outlines the initial way that the children met each other, but this occurred at almost 2 o'clock in the morning in the library of the cruise ship where the probable cause outlines the acts that both of the men committed together on the child. The bonds set in Mr. Martinez's case are $15,000 for the child abuse count and $1,000 for the false imprisonment count. And I would argue that since they acted together in concert, there's no reason to...
The other gentleman, did he have a criminal record? The other gentleman?
Not... No, Judge, he doesn't have a record, arrests, but no convictions.
Now...
Your Honor, and I can answer as far as, because I was present when I believe it was Judge Secor that set the bonds.
I can't hear what you're saying.
I was present when Judge Secor set the bonds on his co-defendant. And the reason why, I think the factors that Judge Secor took into consideration, one, the allegations, and two, I believe his co-defendant also is a resident of the state of Ohio and wanted to set a bond that would ensure his future appearance in court.
Okay, and
also, let me let you know that there was a change of charge capias that was filed with respect to Mr. Martinez, the co-defendant, who voluntarily appeared after he had posted the bond, flew down, and Judge Bailey allowed the bond over the state's objection to remain what Judge Zakor had said.
Tell me about your client's ability to post bond.
I am doing this case at a very low rate.
Okay. Can we just inquire about his financial?
Yeah, sure. Jason, the judge is going to ask you some questions about your financial ability so that he can set a bond that's reasonable and will assure your return to court.
Sir, are you currently employed?
Yes, sir.
What type of work do you do?
I build Jeeps,
You work,
cars.
You work for Chrysler?
Yeah, Mobus, yes.
Okay, and so you work as a member of the United Auto Workers?
Yes.
Okay, and how long have you worked for that company?
Just around like 3.5 years.
Okay, and you're a member of the union, am I correct?
I'll take care of it. There's no way.
Yes, sir.
Okay, and do you have any money in the bank?
A few $100s, I believe.
Okay, and do you, let's see, do you own land or property up in Ohio?
No, I rent, sir.
Do you have family down here in South Florida?
No, sir.
Do you own land or property in South Florida?
No, sir.
Do you have, okay, all right. Do you have any finances to, other than what you told me, a few $100s to post a bond?
No, sir.
Okay. Okay, so you suggest 15 and 1, correct?
Yes, the
15,000.
same as, yes.
In your position, sir?
Judge, based on what the co-defendant who was arrested when he came off the ship and the state filing the charges at a much later date after this defendant left the jurisdiction, I don't think should be an issue. I think that a reasonable bond in this case is $7,500.
And he does not score prison?
They both do, Your Honor.
Score
They
prison?
face, Mr. Lawson faces 19.5 months at the bottom of the guidelines. Mr. Martinez faces more because Mr. Martinez has an additional count of lewd and lascivious conduct.
Okay, the court today is going to set, and the court does, reading the facts, it does look like the defendant is just factually less culpable than the co-defendant. The co-defendant took some other actions. So the court's going to set count 1 on this defendant at $10,000 and set count 2 at $1,000.
Okay.
So his total bond's $11,000 today. And the court does take into consideration he's got good employment, he has no criminal record, he's with a good company, he's a union member. So those are all things in his, and it's a unique situation. Okay?
Thank you, Judge.
So I did give him a.
I appreciate your consideration. Thank you very much.
Thank you very much, sir.
Thank you, Your Honor.
Hey, may I see both parties up here real quick?
She's in,
Well,
Cindy Colbert.
Robert.
Hello, Miss Colbert.
Good morning, sir. Good afternoon, sir.
Hi, ma'am. Trespassing. Court finds probable cause. I know you were in here not too long ago, a week or two ago, allegedly intoxicated, trespassing a week ago, and now
Same location.
intoxicated again, allegedly trespassing in front of the Davie Chamber of Commerce. And the police say this is an ongoing problem in Davie with you being intoxicated and
Extra trespassing. I'm moving to Hollywood.
Yes, ma'am. Ma'am, I know you have no money, and I know you have no way to bond out of jail. I'm going to set your bond at $250. Just based on your lengthy record, this is a constant problem. If we sent her to Judge Lerner,
Sure.
Can I do another contest?
Wouldn't hurt.
no, I'm going to send you to Judge Lerner.
Can you appoint the public defender to represent her?
No contest. I want to go home, sir.
Well, ma'am, you end up leaving jail every time I let you out. You go back to Davie, and you go out and create a problem. It doesn't look like you're going to a home.
I'll see you tomorrow.
As a matter
I'm
of
going
fact,
to I'm going to Hollywood today.
yes, ma'am.
I'm moving to Hollywood. I already talked to Dave Place about that. Too much trespassing and everything. Way too much. That's why I told him I'm moving to Hollywood.
Okay, thank you, ma'am. Your bond's $250. How about Ariam Almonte?
Main jail.
Violation of probation. That's a no bond hold. Thank you.
Caleb, Roger.
Tayana Clement.
Afternoon, Your Honor.
Hi.
I'm sorry.
Wrong one.
Clement, grand theft, count 1, 1,000, 2 and 3 are warrants, 500 per count. Thank you. How about Caleb Rogers Wolski and Steve Blanchard? Wolski and Blanchard, come on up. Rogers Wolski, you have a warrant on a misdemeanor.
He's trying to resolve this, if you will.
Cannabis. Would you like to plead no contest, sir?
You want to resolve it? Please no contest?
Yes, sir.
Sir, if you plead no contest, the case is over with. You're not going to
Yes,
have a
sir,
trial.
no
You're not
contest.
going to have your day in court. It's wrapped up right now.
Yeah.
You understand?
Yes, sir.
How do you plead, sir?
No contest.
Accept out of withhold adjudication. Good luck, all right? Thank you. How about
Good luck,
Steve
sir.
Blanchard?
President, the main jail judge.
Blanchard,
Mr. Blanchard wants to fight this. Can we get an ROR?
probably. Let me find out. Sir, do you still want 5th Avenue in Fort Lauderdale?
Yeah.
Is there an
Yes, sir.
apartment
Yes,
or
sir.
unit number there?
2.
Number 2, okay.
Um.
I'm going to release you from custody, all right? I modified. I just added an apartment number there. Okay. Okay, what about Joseph Woodford? Hey, you know what, who did his bond back?
Who are we looking for, Judge?
Joseph Woodford.
Medical
North
reset.
Broward?
North Broward.
He's a medical reset.
I'm going to reset him for Friday PM. I'm going to find probable cause.
Christopher.
Friday PM, he's been in here quite a lot in the recent. Yeah. How about Edward Mahone?
He bonded.
Bonded. How about Andrew White?
Judge, he stepped out of the courtroom. Can we recall
How
him?
about Christopher Thurlow?
Main jail?
Sir, possession of methamphetamine. Court finds probable cause state. Do we have a criminal record on Thurlow?
Different white.
That's white right now?
Different white.
A different white? Oh.
Yo.
Thank you.
resisting without violence, 2014. Violation of pretrial release conditions, 2014. Battery, 2014.
Okay, Mr. Miller, anything you'd like to say?
Judge, Mr. Turlow is currently unemployed. He is a 4-year resident of South Florida. He does have a place to live. He'll be asking his roommate to bond him out.
Okay, sir, based on your criminal record, your bond's $1,000. Thank you. How about Travis White?
Hey, actually,
Travis
let me
White.
play right back. The guy I was calling you about has his hearing up right now.
Judge, Mr. White is back in the courtroom. Judge, this is Travis White. Michael Weinstein is his attorney. Mr. Weinstein's out of town, Judge. Wanted to know if we could reset this tomorrow, see if someone can cover for Mr. Weinstein.
I'll give him tomorrow afternoon, PM Thursday, all right?
Okay.
He just reset it for tomorrow.
How about
No, but
David
he's
Crowder,
being held
Jack
on burglary, so we can't get that anyways.
DiGraziano, and Cody Florence?
And Judge, Andrew White is now back in the courtroom.
I'll call it up in a
This
moment.
is Mr. Crowder.
Crowder, possession with intent to sell methamphetamines, court finds probable cause. Do we have a criminal record on Mr. Crowder? Mr. Crowder, are you currently employed?
Update you tomorrow. Just wanted to
Judge, Mr. Crowder works at Starbucks. He's been there for about 10 years. 6-year resident of South Florida. He is a registered voter here in Broward County. Not sure who's going to help bond him out.
Okay, sir, I'm going to let you bond out for $2,500. I realize you have no criminal record. However, it does say that you admitted that you're dealing in methamphetamines. You're a seller. The court's concerned about the safety of the community. There you go. Thank you. How about Jack DiGraziano?
Nope. That's it. No problem, Your Honor. You'll bring that up in your division.
DiGraziano, possession with intent to sell, deliver methamphetamines. Count 1 and 2. 3, possession of GHB. 4, possession of alprazolam, also known as Xanax. 5, possession of cannabis. Court finds probable cause. Do we have a criminal record on this gentleman?
One moment, Your Honor.
Mr. DiGraziano, are you currently employed?
I am employed, yes. I start on the 30th.
What type of work is that going to be?
It is photographer, videographer, editor, and for a fashion company and a studio that's opening up.
Do you have any money in the bank?
I have a little bit of money in the bank. I do have my money, some investments for that, and I have my friends who are waiting to go ahead and pay me out.
I understand. How much money would you say you have in the bank?
Right, it says about $200-300.
Okay, do you own land or property in South Florida?
I'm sorry, what?
Do you own land or property in South Florida?
No.
Do you have family here in town?
Yes.
Who do you have?
My whole family lives here.
Okay, sir, I'm going to go ahead. The court is concerned with the safety of the community. Sir, I note that you allegedly admitted to selling methamphetamine, and that gives the court great concern for the safety of the community. Allegedly, you did it on January 12th and January 30th. You were involved in the sale and transactions of methamphetamine.
There's a question as to, like, they claim it's 2 separate transactions. I'm not arguing probable cause, but why didn't they make an arrest on that particular date? It just rings bell. The cops go in, and then they see these drugs, and they said, okay, we're not going to make an arrest. I mean, it's very odd.
Could have blown an investigation if they made an arrest. Okay, so let me, so I'm going to set your bond on count 1 and 2 at $2,500, 3 at $1,000, 4 at $1,000, 5 at $100. Your total bond today is going to be $7,100. Based on the facts of the case, the court's concerned that you're in you're drug dealing. You're dealing in methamphetamine. Thank you.
Judge, will the court ROR count 5? The $100 bond.
I'll do that. I'll ROR on 5. Thank you. How about Cody Florence?
Okay. Judge, did you want to do Andrew White?
Oh, I'm sorry. We'll do that right now. How about Andrew White?
Main jail.
Possession of methamphetamine. The court finds probable cause. State, do we have any priors on Mr. Andrew White?
He has a warrant out for him.
Out of where?
Looks like Illinois.
And what's that for?
Failure to appear on drug paraphernalia case, October 30th, 2014. He, what's his BCCN number, Judge?
It is 841629.
He had 2013 out of Flagler County battery, 2 counts, resisting without violence, 1 count. Obstruct officer without violence, 2012 Daytona Beach. Other priors out of Illinois. One moment, moving on to South Carolina. Shoplifting 2013 out of South Carolina.
Okay, Mr. Miller, anything you'd like to say?
Judge, Mr. White's been down here for about 5 years. He was a secretary assistant to Larry Steinberg, CPA. He has no money in the bank to bond himself out. He'll be asking his boss to do it for him.
So I'm going to let you bond out based on your criminal record, which is kind of lengthy, multiple batteries, thefts, drug paraphernalia. You can bond out, sir. Thank you.
Good luck. Thank you. Florence.
Okay, how about Cody Florence, sir? Burglary of a dwelling and grand theft auto. The court finds probable cause. State, do we have a criminal record on this defendant?
Juveniles? One moment, Judge. No record, Judge. No, I didn't mean if you personally had any juvenile.
No criminal record. Let me ask this. No criminal record. Anything you want to say on behalf of Cody Florence?
Judge, Mr. Florence does work. He works at a place called Exotech. It's a concrete construction firm. He's been here his whole life. He does have strong family ties. He's going to be asking his family to bond him out. He has no money of his own.
Let me ask you, when was the last time you actually went into work to that company?
When's the last time you went to work at that company?
Oh, like 2 weeks ago.
Why 2 weeks ago?
Because like I had to go out of town. I just got back. So
Where were you?
I had went to Chicago for a family visit.
Okay, all
I
right.
visited my grandma
How long have you worked at that company?
for like 3 months.
All right, when are you supposed to go back to work?
When I get out, I guess. I supposed to have been went back. But I'm going back when if I burn out, Your Honor.
Sounds a little sketchy, but, okay, so I'm gonna go ahead, based on these facts, I'm gonna say your bond on count 1 at 1,000, count 2 at 1,000. Your total bond's 2,000, you can bond out, all right, thank you.
Good luck. There you go. 2,000 bonds.
George Cuesta.
To a bond.
Edward Cuesta.
Main jail.
Good afternoon, Your Honor. Probation, that's a $5,000 bond, thank you. Julian
Remember, if you bond out.
Hernandez Cardona, Arthur Melton.
838.
Hernandez Cardona.
Judge, we need a phone order for Aaron Zales Cardona.
We'll order that. Sir, count 1 or 2, possessing harmful new legend drugs. 3, possession of alprazolam. The court finds probable cause. Are there any priors on this gentleman?
One moment, Your Honor. No, Judge.
No. There's no criminal record.
Pre-trial, Judge?
Judge, Mr. Cardona has been here for about 2 years. He works as a hairstylist inside the aisles. He has about $200 in the bank. I'm not sure who's going to help bond him out. Any chance we can get pre-trial for him?
Yeah, let me just confirm his address. You still live on 2nd Street in Hallandale, sir?
You live in Hallandale?
Yes.
on 2nd Street.
Yes.
Yes, Judge.
Is there an apartment number or unit number there?
Apartment?
No, it's efficient. It's home, but it's efficient.
No, Judge.
Sir, I'm going to release you on your own recognizance. You have to get a pretrial release tomorrow morning between 8 and noon. They'll give you a map right there. You're going to be drug tested and have a drug and alcohol evaluation, all right?
Okay, mañana, okay?
Thank you.
Right here.
Arthur
Mañana.
Melton.
Okay. They never brought him down, Judge.
Okay.
Your Honor, I can tell you,
Go ahead.
I reached out to the probation officer supervising him in Dade County, and they have to, and I had the PC affidavit scanned and emailed to him. He's sending it up to Georgia. Hopefully, it won't be much more than a week for Georgia to make a determination if they're going to seek a warrant on him or not. At this point, there's really nothing I can do. There's really nothing that can be done until I know if Georgia's going to seek a warrant. If they're going to seek a warrant, then it's really a moot issue. If they're not, then he might be inclined to resolve the case. But like I said, won't know until I hear from Georgia.
Okay, so
Put him on a second look.
I'll put him on.
Your Honor, what I can do,
Go ahead.
as soon as I hear from Georgia, I'll contact March to have him placed.
Do we put it on Monday? Monday?
Don't
Monday
bother me.
PM. All right. There you go. How
Hey,
about,
you may say
John.
they didn't bring him down either.
John, no. Okay. Well, I'm going to go ahead and find probable cause on one, and
Who is this?
probable cause on two is Guillaume.
Judge, can we just reset it for one day, even though we found probable cause? It's a new charge.
Well, yeah, I mean, it was reset from yesterday. We have to, I guess, get him down here. We can't do anything on him with that. Trace.
Okay, what's he on probation for? Or what is he?
It's, I think it's, yeah, I think it's the same charge. Trace.
He's got a court date on the 19th with Judge Uson. I'm going to go ahead and set his bond on count one at $5,000. Count two is going to be held no bond. I'm going to find probable cause, let him go to his division. Richard Kittles, didn't he come to court today?
Yes.
So he's ROR on this.
I know, I gave that to you. See, that's.
How about Delio?
Yeah.
Mazer.
Don't hand me all of them.
Delio, Mazer. Missouri,
Yes, Your
Ortiz.
Why is that a problem? Why is it?
Conti?
Hey, sir.
Hey, Judge, we're clear at the main. May I be excused?
Yes, sir.
Thank you, Judge.
Okay, how do you say your last name, sir?
Mazariegos Ortiz.
Mazarregos
No, I don't understand
Ortiz.
your English.
So you have a DUI, property damage. Count one. Count two, a DUI. It's his third offense with intent. State, is this a change of charge?
One moment, Judge.
Hey, what did I do on Rogers Wolski? Anybody remember?
Understand this system.
Do you know Rogers Wolski? Anybody know what I did on that? Rogers Wolski.
I have no idea why that goes in there.
Well, how much was his bond originally?
500.
Okay, thanks. Got it.
Sheila, do you know what these bonds were originally? Mazarigos Ortiz.
Oh, that's the guy you talking about. Originally, it was set at 10,000 on one and 5,000 on two.
There you go.
Sir, I'm going to just reset your bonds. Today, this is really just kind of a ministerial type of thing. Count one is 10,000, two is what, 5,000?
Yes.
Count two is 5,000. All right, sir, your bonds will remain the way they are. Total bonds 15,000. Thank you.
Thank you.
Yes, sir. Okay. Now, State, can we ROR any of these felonies?
Some of them, I think.
Do you have the orders up there on the felonies? Did you say all of them?
No, not all.
No.
Valerie Martin can be ROR'd.
May I see Arthur Tisdale? Arthur Tisdale, please.
No brow, Your Honor.
No, you got one more.
Hello, Mr.
All
Tisdale. Sir, I'm looking on the computer. It says the state of Florida filed a formal charge against you on January 13th of 2016. I'm going to look at that document. It says the state of Florida versus Arthur Lee J. Tisdale. Resisting police officer with violence. And I'm looking on the second page, signed and sworn to by Stacy Dorenzo of the State Attorney's Office. Do we have any objection?
No, Judge.
Mr. Tisdale, today the court's going to deny the motion to release you on your own recognizance. All previously set bond and release conditions shall remain in full force and effect. Thank you, sir. I see Michael Davis.
Conti.
Hello, Mr. Davis.
How you doing, sir?
Good. I need to figure out whether they filed a formal charge on you. Let me look at the computer. Michael Davis right here. State filed a formal charge January 13th, 2016. Let me pull that up. State of Florida versus Michael A. Davis and Jonna Jones. Okay, I need to look at the individual counts here. Okay. Count 1, burglary of a dwelling armed. Give me a moment. Count 2 is robbery with a firearm, discharging the firearm. Count 3. Is, just give me a moment here. Count 3 is shooting into an occupied dwelling. You're charged with that, but not your co-defendant. Count 4, aggravated battery on a pregnant female. Give me a moment. You're charged with that alone, not with your co-defendant. And count 6, you're charged with count 6 alone, not with your co-defendant. And that is, count 5 is aggravated assault. So it looks like you and your co-defendant have 1 and 2, but count 3, 4, and 5 are only you. All right? So do we have any comment by the defense?
No.
Mr. Davis, today the motion to release you will be denied. All previously set bond and release conditions shall remain in full force and effect. Thank you. Now, following people, please come forward, line up. Valerie Martin. Ma'am, you're going to be released on your own recognizance. Thank you. Good luck.
Yes, sir. Thank you.
You're welcome. Andrea Davidson, LaQuisha Mosley.
Press the button.
Are you Andrea?
Yes.
Ma'am,
Yes. Hi.
You're going to be released on your own recognizance. Thank you.
Thank you.
You're welcome. LaQuisha Mosley.
Take care. Bye.
LaQuisha Mosley. I don't see her. You gonna wave? It's an RR.
Yes, of course.
Okay, I'm gonna in absentia find. She's gonna be released to ROR, Miss Mosley. How about Jacob Bay? Jacob Bay.
No problem, Your Honor.
Mr. Bay, you're gonna be released on your own recognizance. Thank you.
Thank you, sir.
You're welcome. Kejo Williams.
No.
Kejo Williams. Delete. No action. Here we go. Now we have one more, I think. We have a female there. What's your name, ma'am? Come on up.
Yes, sir. Step up.
What's your name?
Bella Rose, sir.
What is it? I don't have it on the docket.
It's a misdemeanor.
Oh, okay. Arian Bella Rose?
Yes, sir.
Wasn't she supposed to bond
Yes.
out?
Okay, ma'am. Just give me a quick moment.
I know, but she was. I thought Marge heard from somebody that she was bonding out.
Press the button. They'll let you in. PA 129.
Ms. Bellarose, you've been in jail for
Yes.
several days now. How come
Yes.
how come you've not bonded from the jail yet now?
Because I know nobody here, sir. I'm from Canada.
Well, you don't have any family in South Florida?
Well, I have one, but I don't have my cell phone with me,
Wait,
so
who do you have in South Florida? Who's the relative?
Judge, she lives on the beach. I remember her. I can tell you about her.
Yeah.
Let me ask you. Who is the relative you have here in South Florida? ma'am?
It's a boyfriend. I have a boyfriend here.
How long have you had your boyfriend?
3 months.
How long have you been in jail?
5 days.
Is your boyfriend, does he have a job?
No, this
No, I don't have a job here. I'm not allowed to work here yet.
How about your boyfriend? Does he work?
Yes, he works in a school.
Judge, I could tell you about her. I spoke with her on Monday. Judge Canner was going to, Judge Zakor originally released her to pretrial release. She does have an apartment on Ocean Boulevard. What I'm saying is correct, right? Judge Zakor released her pretrial release. We got information later on that she bonded out, so what Judge Zakor did was put the bond back instead of the pretrial release.
The information was, considering Marge was the one that brought it to Judge Zakor's attention, I imagine it was contact from a bond agency that they were going to bond her out.
So I'm going to ask the court to release her pretrial release. That was the original intention, was to release her.
When I'm out, I can pay it.
I know. I'm convincing I'm asking the judge to release you to pretrial release. I discussed that with you on Monday.
Yes.
That was a Freudian slip right there. I can't see it from his the judge right now. Okay, ma'am. I'm going to release you on your own recognizance today. However, tomorrow morning you need to report to pretrial release. It's an office in downtown Fort Lauderdale, just next to the courthouse. They'll give you a map right there. You have to be there tomorrow between 8 and noon time. You are
No problem.
You are not allowed to consume any alcoholic beverages while you're on release. Is that clear?
Yes, sir.
Okay, ask the person there to give you a map to pretrial release. They'll give it to you, all right?
I already have it, I think. But yes, okay.
Okay.
I think I received it 2 days ago.
Okay, all right, ma'am. Thank you.
Thank you so much.
You're not allowed to drink, no alcohol, okay?
I know.
Okay.
I know. Thank you.
Thank you. All right, I think that's a wrap. Am I correct?
Yeah.
Thank you, everyone. Thank you very much. We'll be back here tomorrow morning, Thursday morning, bright and early, in room 235. However, the court runs late to this because I have to do extraditions in the morning in another courtroom. It throws me late in here, maybe quarter of, maybe 10 of. I'll see you in here. All right, until then, we're out from 235. Have a good night.